Hello, welcome to EPG Pathshala. My name is Maruk Aidenwala. I'm taking the course Legal Literacy. This is Module 2. Here again, we continue to deal with different provisions of the Constitution. In this module, we are going to look at certain fundamental rights which are important for a social worker to understand. Article 14, Equality before law. This provision falls within the category right to equality. Equality before law, Article 14, is one of the most important fundamental rights. Equality is a basic value of a democratic political system. What does Article 14 say? The state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. There are two aspects to Article 14. One, the law should treat everyone equally. Two, the law should be applied equally to all. Statutes or legislations on paper treat everyone equally. The problem arises in its application, where there is lots of discrimination. The focus is on ensuring that such practice does not continue. Article 14 also castigates arbitrary action on the part of the state. Now let us look at the different types of equality. There are two types of equality: formal equality and proportional equality. Formal equality treats everyone equally, irrespective of their situation in society. All are treated in the same manner. Two, proportional equality, also called substantial equality, acknowledges that everyone is not in a similar situation and does not forbid different treatment of unequals. Positive discrimination and reasonable or legislative classification is a part of proportional equality. India follows proportional equality. In India, we acknowledge that everyone is not at the same level. Hence, in India, people in equal situation are treated equally. Unequals may be treated differently. Hence, the state is required to intervene to help the weaker sections come on par with the rest. Reasonable classification. Reasonable classification and legislative classification mean one and the same. What do we understand by reasonable classification? Please read this slide closely. It allows categorizing into groups people who are different from the rest and having special legislation to protect and promote the rights of those in that group. To meet the test of reasonable classification, the courts see, one, whether that particular group has differences with the rest, which makes those in that group weaker, requiring legislative support. Second, the legislation which is enacted should address these differences which makes the person weak. For example, the Right of Persons with Disabilities Act 2016 acknowledges that persons suffering from disability are different from the rest and require special protections. Therefore, certain concessions and incentives are given with regards to employment and education to those belonging in that group. Article 15 deals with non-discrimination on grounds of religion, race, caste, sex, or place of birth. 1. The state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth, or any of them. Clause 1 applies to state agencies. The state, while performing its duties, has to ensure that it does not discriminate against people on these grounds. Clause 2. No citizen shall, on grounds only of religion, race, caste, sex, place of birth, or any of them, be subject to any disability, liability, restriction, or condition with regard to A. Access to shops, public restaurants, hotels, and places of public entertainment, or B. The use of wells, tanks, bathing ghats, roads, and places of public resorts maintained wholly or partly out of state funds or dedicated to the use of the general public. It's important to understand Clause 2. Clause 2 is to be adhered to both by state actors as well as private parties. For example, a person owning a hotel which is open to the general public cannot restrict a particular person to enter only because he belongs to a particular religion, race, caste, sex, place of birth, or any of them. Hence, wells, tanks, etc., which are accessible to the general public cannot be restricted to a person belonging to a particular caste. Clause 3. Nothing in this article shall prevent the state from making any special provisions for women or children. Clause 3 is an exception to Article 15, Clause 1. Clause 3 allows the state to enact laws for the protection and promotion of the rights of women and children. For example, Section 498A of the Indian Penal Code punishes a husband or in-laws who treat a woman cruelly. It only applies to women, and such provision is upheld because the state recognizes that women undergo cruel treatment at the hands of their in-laws and require special protection. Clause 4. Nothing in this article or in Clause 2 of Article 29 shall prevent the state from making any special provision for the advancement of any socially and educationally backward classes of citizens or for the scheduled caste and the scheduled tribe. Clause 4 is also an exception to Article 15(1). It recognizes that special laws may be enacted for the benefit of scheduled caste and scheduled tribes. We must recognize that scheduled castes and scheduled tribes have undergone discrimination over a long time. Hence, special laws can be created to enable to reduce the gap between the scheduled caste, scheduled tribes and the rest of society. These exceptions are called positive discrimination or affirmative action. We must recognize that when we say that people Unequal people may be treated differently. They can be discriminated against, but only positively. There can be no negative discrimination. This judgment of the Supreme Court is very interesting, as it lays down the rationale for Article 15, Clause 3 in the Constitution in the context of women. Please read it carefully. The insertion of Clause 3 of Article 15 in relation to women is a recognition of a fact that for centuries, women of this country have been socially and economically handicapped. As a result, they are unable to participate in the socio-economic activities of the nation on a footing of equality. It is in order to eliminate the socio-economic backwardness of women and to empower them in a manner that would bring about effective equality between men and women that Article 15(3) is placed in Article 15. Its object is to strengthen and improve the status of women. This is the essence of positive discrimination. Article 16. This deals with non-discrimination in matters of public employment, that is, employment in state office. 1. There should be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. 2. No citizen shall, on grounds only of religion, race, caste, sex, descent, place of birth, residence of any of them, be ineligible for or discriminated against in respect of any employment or office under the state. What does Article 16, Clause 1 and Clause 2 indicate? These clauses show that the state cannot discriminate in matter of appointments to a public employment. You cannot discriminate against a person and reject him for employment merely because of the religion he belongs to, the race he belongs to, the caste he belongs to, sex he belongs to, descent or place of birth. For example, if there is an advertisement in a newspaper calling for appointment for police personnel, and if they say women not to apply, such an advertisement violates Article 16, Clause 2. Clause 4 of Article 16 deals with reservation. Nothing in this article shall prevent the state from making any provision for the reservation of appointments or posts in favor of any backward class of citizens which in the opinion of the state is not adequately represented in the services under the state. This clause acknowledges that there are certain class of citizens who do not hold any state office. And by this provision, the state is allowed to make a quota to ensure that there is representation of such class of citizens also in state services. The concept of reservation is explained in Article 15, Clause 4 and Article 16, Clause 4. The Indira Sawhney versus Union of India case is an extremely important case with regards to reservation. It also clearly lays down the reasons why reservation is important in a country like India. The fundamental question is, what is the raison d'etre of reservation and what are its limits? The Constitution permits the state to adopt such affirmative action as it deems necessary to uplift the backward classes of citizens to levels of equality with the rest of our countrymen. This is the essence of proportional equality. Because in our country, people are at different levels. Certain classes and castes have been discriminated against for centuries. So to expect them to come onto the same level of equality with the rest of society is almost impossible, except if the state gives it certain concessions in employment or for admission to educational institutions. The objective behind Clause 4 of Article 16 was the sharing of state power. The state power, which was almost exclusively monopolized by the upper caste, that is a few communities, was now sought to be broad-based. The backward communities, who were till then kept out of apparatus of power, were sought to be inducted thereinto, and since that was not practicable in the normal course, a special provision was made to effectuate the said objective. In short, the objective behind Article 16(4) is empowerment of the deprived backward communities to give them a share in the administrative apparatus and in the governance of the community. It is extremely important that voices of different classes be heard in governance and in administration. It cannot merely be left to an elite section of society, because it is in administration that interests of the different sections of people is considered and decisions are taken in that respect. So to ensure that the political interests of the backward classes is also kept in mind while administering, it is important that reservation be made. Now we go to another category of fundamental rights, that is the right to freedom. Article 19 is an extremely important article. It is titled Protection of Certain Rights Regarding Freedom of Speech, etc. Article 19 lists different freedoms. All citizens shall have the right to freedom of speech and expression. Expression includes even writing. Freedom of speech and expression is a right enjoyed by the media. Freedom of speech and expression does not merely include the freedom to express, it also includes the freedom to know, the freedom to what another person wants to say. Therefore, censorship is derogatory of Article 19, Clause 1, Subclause A. Clause B, to assemble peaceably and without arms. Hence, demonstrations are and peaceful protests are allowed under Article 19. C, to form associations or union or cooperative societies. D, to move freely throughout the territory of India. A person residing in Bihar doesn't need a visa to come to Maharashtra. E, to reside and settle in any part of the territory of India. A person can reside anywhere in India, no matter where he is born. G, to practice any profession or to carry on any occupation, trade or business. Article F has been omitted. Article F dealt with the right to acquire, hold and dispose of property. As important the concept of social justice is to our constitution is the concept of distributive justice. Article 19, Clause 1, Subclause F derogated distributive justice. Article 19, Clause 1 has certain exceptions. These In Article 19, Clause 2, these exceptions to the freedom of speech and expression are laid down. Please read this closely. Freedom of speech and expression can be denied to a person only on the following grounds. What are these grounds? They can be denied in the interest of the sovereignty and integrity of India, the security of the state, friendly relations with foreign states, public order, decency or morality, or in relation to contempt of court, defamation, or incitement to an offense. These are the only grounds on which the right to freedom of speech and expression can be restricted. But the restrictions, the Supreme Court has repeatedly said that such restrictions should be reasonable. They cannot be excessive. Another important characteristic of Article 19, Subclause 2 is that in order to restrict the right to freedom of speech and expression, the state requires to enact laws restricting the same. Reasonable restriction. Let's just look at this judgment, State of Madras versus V.G. Rao, which describes what we mean by reasonable restrictions. It is important in this context to bear in mind that the test of reasonableness, wherever prescribed, should be applied to each individual statute impugned, and no abstract standard or general pattern of reasonableness can be laid down as applicable to all cases. This means that reasonable restrictions will differ from case to case. There cannot be a blanket application. Next, the nature of the right alleged to have been infringed, the underlying purpose of the restriction imposed, the extent and urgency of the evil sought to be remedied thereby, the disproportion of the imposition, the prevailing conditions at the time should also enter into the judicial verdict. Hence, a restriction which may be reasonable 10 years back may not be reasonable today and may become excessive. Kedarnath Singh versus State of Bihar is a Supreme Court judgment of great importance. Today, the freedom of speech and expression is being restricted on the ground that it may create a public order situation. In Kedarnath Singh's judgment, the Supreme Court clearly lays down that merely criticizing the government does not amount to a public order situation. Comments, however strongly worded, expressing disapprobation of actions of the government without exciting those feelings which generate the inclination to cause public disorder by acts of violence would not be penal. In other words, disloyalty to government established by law is not the same thing as commenting in strong terms upon the measures or acts of government or its agency so as to ameliorate the condition of the people or to secure the cancellation or alteration of those acts or measures by lawful means. That is to say, without exciting those feelings of enmity and disloyalty which imply excitement to public disorder or the use of violence. So, mere criticizing the policy of the state does not amount to a situation where you are inciting people to use violence or your intention is to create public disorder. Hence, restricting such words is not a reasonable restriction. In Module 2, we have examined two especially important fundamental rights, that is Article 14, right to equality, and Article 19, the freedoms. These two fundamental rights are the foundation of a democratic political system and must be adhered to. Most important is the restrictions to Article 19. These restrictions should not be excessive. The restrictions should not be such that it denies a person their rights to freedom. A very detailed text has also been uploaded. Please go through that to better understand what we have seen in this PowerPoint presentation. Thank you.